In the late 1970s, I began to receive inquiries from clients about problems their aging parents were having. And what was remarkable was that very few people in the legal profession had any knowledge or experience in dealing with these problems. And this was not just a few clients, this was a large number. And when I looked at the demographics, I found that while we were pushing back the mortality tables and people were living longer, 50% of people at the age of 85 or above were not living well. They were really unable to perform the activities of daily living as a result of strokes, dementia, and other kinds of medical problems. This was a growing problem that America was not facing. Around the same time, I received a phone call from a colleague of mine who was the head of social services at a major New York City nursing home. And she said, "I've got this couple. The man's had a stroke. He's going to be in the nursing home for the rest of his life. The wife lives on $300 a month Social Security, and Medicaid will pay for his care in the nursing home, but they're only going to give her another $200 out of his income." And I brought a lawsuit representing the wife, suing the husband for non-support. And the state went absolutely crazy. They said, no, 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 no. He's now receiving a form of welfare. He's got to turn over all of his income to the state of New York as his contribution to the cost of his care, now paid for by the Medicaid program. It became a choice between the individual's right to support from a spouse versus the right of the taxpayers to have some contribution. And the family court judge saw that the individual right prevailed. And we developed, along with some of my other colleagues that began to handle similar suits, we developed this concept of the rights of a spouse for support.